Let's talk about something that is a big thing now in financial planning, at least in my practice. Now, my practice is 34 years old. All right, so we're not a young firm, and many of my clients are aging and become elderly now. Many of my clients have been with me 25 years, some even longer. And they came to me in their 60s, and now they're in their late 80s, early 90s. And what we're dealing with now is not necessarily investment planning and tax planning, it's end-of-life planning. And that's a big area of financial planning that a lot of financial planners are not experienced with and really aren't very good at helping you. They'll refer you to an elder care attorney and so forth and so on. Because so many of my clients are dealing with these issues, I've been forced over the years to become proficient in how to deal with end-of-life planning. And many mistakes are made here. And, we have to face it. We have to face the fact, that we're not going to be here forever. So we got to plan end-of-life issues, whether it's estate planning, whether it's asset protection for nursing home, whether it's tax planning for inheritance. And, we plan to have a good day, we plan to have a good year, we plan to have a good retirement, we plan to have a good life. Why not plan for a good end of life too? And the way you plan for an end of life is before you're there. It's very difficult to do end of life planning when there's such a short time frame. We have look back rules as far as gifting strategies go to get money out of your name to protect from nursing home. You got to do this at least 5 years before you would need that long-term care. So you have to anticipate it. Now, one of the hardest things that I do in financial planning is advise on this long-term care issue. Because people are deathly afraid of this. They've seen it happen in their families and their friends. All their money disappeared to a nursing home. And they certainly don't want that to happen to their nest egg that they took their whole life to build up. And it's very common for people to say, oh, I worked my whole life to build up this money and the nursing home's going to take it all. And that's another thing. That's another phrase that people use that is not correct. Nursing homes don't take your money. They don't take your house. The bottom line is you have to pay for it out of your own pocket until your money's gone before you get Medicaid, which is state aid, to pay for it. That's how it works. They don't take anything. And I got to chuckle every time someone says that. Oh, they're going to take all my money. They're not going to take anything. You're going to pay them all your money for the service of long-term care or custodial care. And you'll pay it every month until you qualify for Medicaid. And those rules are different if you're married or if you're single. If you're single, everything goes. Everything goes that hasn't been aged 5 years in the way of a gift. If you're married, the house is off limits. The car, the spouse that doesn't need long-term care can keep half the assets, up to about $130,000. So, for example, if somebody had $500,000, they'd have to spend down $370,000 till there's $130,000 left before Medicaid would kick in. Now, again, if you're single, there's no limit. It goes all the way down to zero. That's why we're not too concerned about long-term care planning when there's a couple, because there is substantial protections for the surviving spouse. But when there's a single person left, now we really have to consider how to protect the assets. And that's when we look at gifting strategies, trusts, and other things. Now, of course, the more assets you have, the more important this kind of planning is. If you don't have much in the way of assets, there's not a whole lot of planning that you can do. But people make a lot of mistakes in their estate planning. And when I say estate planning, I mean anything that's an end-of-life financial issue. And many people don't have a real plan in place. When I say a real plan, everybody has a plan. The plan could be, I have no will, and the state's going to determine where my money goes. And maybe even where my kids go, if I'm young. Or they have a will in place, but they haven't adjusted it over the years. And the solution to this is to be proactive. And it just amazes me how many older clients come to see me, new clients, and they don't have an estate plan. They don't have the basics, a will, a power of attorney, a living will, in their 60s, in their 70s. Oh, yeah, we had one years ago when we lived in Vermont, about 30 years ago, but we haven't had it updated. And that's the one thing about things like the wills and the power of attorneys and beneficiaries and the like. You have to update these plans over time. Estate planning is not something that you just set and forget it. And having a plan just is not enough at times. You have to update your estate plan for major life events. Or when your goals shift, or maybe someone died. Maybe another child was born into your family that you want to take care of. Maybe you move to a new state. You have to realize that, these legal documents like wills and trusts and power of attorney are governed by state law. And moving can cause some issues with this. Now, not all the time. Just because you move doesn't necessarily mean you have to update your will, but you have to have it reviewed to see if there's anything in your will that's contrary to the state law. A change in taxation, or change in state law or federal level. As an example, the Tax Cut and Jobs Act passed in late 2017. That was the Trump tax cut. What did that do? That moved the amount of estate tax exemption to over $11 million per person. So a married couple would pay no estate tax, at least on the federal level, on the first $22 million that they had. Now that pretty much prices most of us out of estate taxes. Also New Jersey, who used to have a $675,000 estate tax exemption. A lot of people got caught up in that in the state of New Jersey. Dying in New Jersey, living in New Jersey is expensive. Dying in New Jersey was especially expensive when we had the estate tax. Because even though the federal estate tax moved up to $2 million, New Jersey kept theirs at $675 up until just recently. And now the estate tax in New Jersey is gone. There is no estate tax in New Jersey, no matter how much money you have. So nobody, most likely nobody, unless there is one fortunate soul out there with $22 million net worth who doesn't really need to listen to this program because they've gotten there already. They don't need my advice. I'm sure they have very high priced financial planners, attorneys, and accountants to do this for them. So I doubt that anybody listening to me will pay estate taxes if you live in New Jersey. And a lot of people have that misconception about that. But you have to consider taxes when you're doing your estate plan. And many people don't plan for the tax liability. Many people out there, as I said, when things change, you got to change. How many of you have a credit sheltered revocable trust out there that tried to take advantage of the $675,000 exemption you had and the $675,000 that your wife had? Many people had these trusts back in the 90s up until when the estate limit went up. You don't need that anymore. The credit sheltered trust is meaningless to almost everybody who has them now. And they're revocable, so you can get out of it if you want. But, before you do that, obviously consult with an attorney or financial planner before you do it. But the credit shelter trust is what all the attorneys used to sell to preserve it. Because if you inherited all your spouse's money, you eliminated their $675,000 exemption. So, but if you had the trust inherit the money, your half, you were able to preserve both of them. A little complicated, but it allowed you to double your estate tax exemption. And it was a very good planning tool when there was a federal $675,000 estate tax, or when there was a New Jersey $675,000 estate tax. Now, nobody pays its estate taxes, so you don't need a trust to avoid it. But there is something that you do have to be aware of in New Jersey, and that's the inheritance tax. That has not gone away. And it's dreadful. It is absolutely dreadful. If your children and grandchildren, or mother and father or grandparents, aren't your beneficiaries, there's an inheritance tax. There's an exemption for straight line up and down. If I inherit my parents' money, no inheritance tax. I inherit my grandparents' money, no inheritance tax. My child passes away and I inherited their money, no inheritance tax. If my brother inherits my money, there's an inheritance tax. And that could be as much as 15%. So I had a client that recently passed, had no children, had over about $2.5 million estate, and all the beneficiaries were non-children, were not direct descendants, and the estate had to pay almost $400,000 in inheritance tax. And the way that works is the executor pays it out of the estate and then distributes the assets net of those taxes. So it comes out of the inheritance of the people inheriting it. Another thing, what kind of asset are you inheriting? Are you inheriting a house, or are you inheriting in someone's IRA or 401k? Big difference. I rather inherit a $500,000 house than a $500,000 IRA or 401k. Why? Taxes. There'll be no taxes inheriting a house and selling it with the stepped up cost basis, which we'll talk about in a bit. But if I inherit my parents' IRA account, I got to pay tax when I take that money out. And now, with the new stimulus law that came out recently, I have to take it out in 10 years. I can't just draw it out the rest of my life. I have to liquidate that entire $500,000 IRA in my peak earning years when I'm at the maximum tax bracket I'm going to be in. That's terrible. That's awful. So if I have to pay 30% in taxes, my sister inherited the house at $500,000, no taxes on it. I inherited $500,000 IRA, and I got to pay 30% tax on it. Well, I'm inheriting $300,000 actually, while my sister inherited $500,000. Do you think most people, when they're doing their wills and figuring out who gets what, are going to think about that? No, it's something that's discovered after the fact. Because most people are ignorant to money. The beneficiaries are ignorant, and the deceased are pretty ignorant if they didn't get good financial advice. Another thing to keep in mind with inheritance, you have to be very cognizant of how assets are held. Because many things do not have anything to do with the will. In many cases, a person's will is inconsequential. Because everything they own is either held by joint title or held by beneficiary. So if you have a checking account, a brokerage account, a home, in your name and the name of one of your children, and you have two children, and the will says my children get 50% each of my assets, that's not what's going to happen. Because by title, the one child is going to inherit that bank account or brokerage account because they're the survivor on the account. Also, anything that has beneficiaries bypass the will. What has beneficiaries? 401ks, IRA accounts, insurance policies, annuities. Again, whoever the beneficiary is on that paperwork is the one who's going to get it. So you got to understand ownership. And I just had a close family member. His wife just died. And, he's older and, he's at the end of his life as well. And he's trying to do his estate planning. And he wanted me to read his will. I read his will, and it was fine. The only problem is the will only affects his house because that's a residual estate asset. It's in his name alone. Well, it was his and his wife's, but now he's the survivor, so now he owns it. Everything else he owns has transfer on death or is jointly held with one of his kids, or is part of an IRA account, or a beneficiary, or an annuity, or life insurance. So he was very surprised to hear that his will really only affected one thing, the home. Everything else is going to go very easily by beneficiary or title. But where the mistake is made is when parents disinherit the rest of the family because of convenience. I put my son's name on my account. No, you didn't. You gifted him half the account, and he's going to inherit the other half of the account when you die, regardless of what your will says. I can't tell you how many people are so surprised to hear that. And you know what? I think I mentioned this example. I know I talk about it in my conference room a lot to clients, but I probably mentioned it on the show a number of times over 20 years. I had a woman come in, first time appointment. She told me her mother had just died, and she wanted help settling the estate. So I read the will, and the will said that all my assets are to be distributed equally amongst my son and my daughter. So I said to the daughter, I said, what's the assets? She goes, a Merrill Lynch account with $900,000 in it in her house, worth about $300,000. All right, so I look at the statement from the Merrill Lynch account, and it had the mother's name and the daughter's name on it. Right? So I said, why is your name on this account? She goes, because my mother, last couple of years, couldn't call the broker and handle it. She wanted me to handle it. Well, that could have been done with a power of attorney. But by putting her daughter's name on the account for convenience purposes, she disinherited her son of $900,000. His half is $450,000. Then I talked about the house, and apparently she did the same thing with the house. Put the daughter's name on it with her, disinheriting the son again. So therefore, by law, the one daughter inherited the 100% of the estate of the mother. The son inherited zero. And there's nothing he can do about it. There's nothing legally he can do about it. The only legal thing he could do is say, my mother was disabled and incapacitated, and not of right mind, and she was coerced by my sister to put her names on those accounts. And then if you could prove that in a court, maybe you'll be successful. But if she did this a number of years before she died, it'd be pretty difficult to prove that. If she did it 3 weeks before she died, you got a better case. But whenever you want convenience, you want your child to be able to transact business for you, call the broker, go to the bank, pay your bills, do it with a power of attorney. It's a simple document. You can go into Staples or go online and get a template and fill it out and just have it witnessed or notarized. And that person is you, can handle all your financial issues without changing your estate plan. Very important. Another thing to keep in mind is that now that the IRA inheritance rules have changed, meaning that the inherited IRA has to be taken out in 10 years, and that may be in your peak earning years of your child, or whoever inherited it, and you're in a lower tax bracket, it may make sense to convert to a Roth IRA. We talked about Roth conversions last week and when it makes sense and it doesn't make sense. Well, it may make sense, and you need an accountant to crunch the numbers for you to make sure. How do you do it? Do you do it over 3-4 years? Do you do it at once? Because there's all kinds of tangential financial issues that could come up by doing too much at one time. It could make your Medicaid go up. It could make you pull you out of the PTR, property tax reimbursement program here in New Jersey. It could take away certain benefits like a pad for drug assistance and senior gold and things like that. So you need to look at everything and get the right advice. But having said that, if over the course of 4 years you converted a $200,000 traditional IRA into a Roth, now when your child inherits it, it's tax-free. They won't pay taxes on it while they're in their peak earning years. So it always makes sense that if you're in a lower tax bracket than the beneficiary is going to be when you die, your best bet then would be to convert to Roth over the course of time. Because now, the rule prior to recently was you take it out over the course of your life expectancy. You would take required minimum distributions. Now they say, nope, no required minimum distributions, just it better be out on the 10th anniversary of that person's death. I don't care if you take it out the last day, the IRS says, or the last year. But if you take it all out in 1 year, God knows what that'll do to your taxes. So now you may be forced to take $50,000 out every single year at a high tax bracket. Very, very bad thing. And that's why planning is very, very important here down the line. All right, let's take a break. 732-505-1160 is the call number. My name's Lou Scatigna. Don't go away.